Hello and welcome to GDPR for HR webinar. I'm Olivia Sinfield and I'm a solicitor from our employment team here in London at OC. I'm accompanied today by my colleague Rachael Oakley. Now these are without doubt interesting times for HR teams on the privacy and data protection front. Times when we're currently on the cusp of GDPR, the General Data Protection Regulation, but still under the shadow of the Data Protection Act and Data Protection Directive. Rachel and I are going to take you through what these changing times mean for HR teams, sort out some of the myths around GDPR, and distill what you should be doing now and over the next few months. So it is ticking. With the summer holidays over, we are now on a 7-month countdown to a new era of data protection compliance in Europe. On 25th of May next year, as I'm sure you're all already aware, a new data security initiative to protect consumers in our new digital economy will come into force. And by the 25th, all businesses will need to have implemented new policies, procedures and practices to address GDPR's requirements for handling personal data. Key aims for today are for you to take away two main takeaway points. First of all, the realisation that given the breadth of the undertaking and the lead time needed to complete the GDPR exercise before the 25th of May, the time for HR teams to get started is now, if you haven't done so already. The deadline shouldn't make this a back burner issue, as many of the steps Rachel and I are going to talk through today will take some months to complete. A further key message is that GDPR compliance is a business-wide transformation exercise and will require engagement from the boardroom down across a whole host of teams, including risk, compliance, IT, commercial, finance and HR teams. So our agenda for today is set out on the slide. We are going to take you through the impact of GDPR on HR processing and really trying to focus on some key issues and points of interest for HR teams, including issues around consent, individual rights, privacy notices, security, and what to do if it all goes pear-shaped in terms of breach reporting. And finally, we'll be summing up with how you as an HR team can and should be GDPR ready. Some context. Why is there a need for GDPR? The answer is fairly simple, and is that our law in this space is lagging staggeringly so behind our technical reality. Those governing our data gathering, storage, use, etc. date back to 1998. And this was our technical landscape back then. We had the Nokia brick, faxes were still on people's desks, international data theft wasn't a concern, and cloud stored RAW and not data. However, times they have changed, and fast forward 20 years to where we are today, this is our technical landscape. We're now in an era of artificial intelligence, robotics, the iPhone X, Apple Watch Series 3, a whole new meaning to words such as likes and streaks. And since 1998, there's been an expansion in digital revolution, and this has had a knock-on effect on the way we process and store data. So that is now, pardon the cliche, not only the oil of our economy, but it's also ubiquitous. It's everywhere in our organisations. There's our data, client data, supplier data, prospect data, data about contacts. And the value of data is increasingly underpinning the purchase and disposal costs of business. So with the ever-changing technical and data landscape, we still had the situation where the legal landscape has been exactly the same until next year, when finally our laws will catch up with this technical reality. Familiar now with the history of GDPR, so only very briefly, the European Commission published the proposal back in 2012, and it was adopted as regulation in spring 2016, and then we've been through a 2-year period of implementation. doubt, GDPR has been one of the most controversial pieces of legislation to go through Brussels. Over the last 4.5 years, there have been some 4,500 amendments proposed by different lobby groups. It took until Christmas last year for agreement to be reached on the text. On the pay side, our statement of intent was issued in August of this year and was followed very quickly by the publication of the Data Protection Bill, which we'll be covering in this morning's session. Of GDPR, they're not for the faint-hearted. They're contained in some 204 pages, 135 recitals and 91 articles. And you can see how this heavyweight compares on balance to the more slimline Data Protection Directive. The objectives of GDPR, there are 4 key objectives. First of all, in relation to harmonisation, the aim is that the GDPR will replace the patchwork quilt of 28 different EU member states' laws with a single unifying data protection law. In view of changes of technology and globalisation. In relation to individuals, the aim is to shift control over personal data back to the public. Basically, to give any EU citizen the right to know how any company is handling his or her personal data. It is to strengthen the obligations for companies. We particularly like to how this is expressed as a positive for business rather than being seen as an extra burden. Without doubt, businesses will need to focus more time, resources and money on compliance. So to address the impact of Brexit, because some businesses, we're aware, may be delaying action until they see the results of the Brexit negotiations. Now, this is a no-brainer, I'm afraid. Our government have confirmed that GDPR will still bite despite Brexit. And the Data Protection Bill makes it crystal clear that we can't take a head-in-the-sand approach, as the UK is pretty much going to mirror the protections offered by the regs. Wants to ensure that UK data protection laws remain essentially equivalent to those in the EU post-Brexit, thereby putting the UK in a better position to ensure adequacy status and secure unhindered data flows. An expression of intent in this regard, the UK government has been particularly cautious when derogating or not, as the case may be, from GDPR. Bottom line, Brexit is not a reason to wait. So I'm going to hand over to Rachel, who's going to address why is GDPR an HR issue.
So you're probably thinking at this stage, that's all very fascinating, but if it's to do with personal data, why is that important to me in HR? Surely it's the responsibility of risk management or the technical experts who monitor your IT systems. Unfortunately not. The rules and changes that are being implemented by the GDPR mean that it will have a direct and profound effect on the everyday work that you carry out in HR. And why is that? Well, this is because HR is a data-rich function, which we've set out on the slide. And this is going to present specific challenges to HR which will not be faced by other areas of the business. HR has a huge volume of data from both job applicants and current employees. You collect a wide variety of data, some of this even being special categories of data, which we currently know as sensitive personal data, and we'll go a bit more into that distinction later. HR collects this data from multiple areas and sources, from the individual itself, from their managers, third-party vendors, and data isn't just collected at the outset of the relationship. It continues throughout the duration of the employment relationship. And not only this, but it's stored often in bizarre places, be that on HR local drives, managers' laptops, emails, etc. So you can therefore see that HR is fundamentally involved in processing a lot of sensitive personal data on a daily basis, and often in an informal way. A lot of managers often aren't aware that what they're doing on a daily basis is processing data. Because of all these systems and processes and different areas for storage, that the compliance regime that you're going to need to follow is likely to be much more complex, and there may be gaps in compliance. So, okay, is important for you in HR, but what does that mean? So, failure to comply with the GDPR has consequences, and going forward, we're going to see tougher enforcement, fines based on revenue, which means a changed risk profile in terms of data governance. GDPR dramatically increases the sanctions in cases of non-compliance, which is a stark shift from compliance with data protection rules being fairly subdued to putting failures to comply in the spotlight, with eye-watering fines for getting it wrong. Levels of fines under the new regime, and that both of them show a big step up from the current maximum penalty of £500,000 in the UK. Now, we know TalkTalk was recently fined £400,000 for failing to keep data secure, and whilst this is a record fine, it's nothing compared to what the new GDPR fines could be. Set out the details on the slide. As you can see, the highest fines could be up to €20 million or 4% of global turnover, and that's not just the turnover of the business that gets it wrong, it's of the entire group company. I also think that this is likely to result in a rise in private claims and also group action claims, because GDPR makes it easier for individuals to claim compensation, which claims for material or non-material damage to the individual. They wouldn't even need to prove financial loss, just distress would be sufficient. So we see disgruntled workers using data protection as part of their leverage in employment disputes. For example, if there's a corporate reorganisation or a mass redundancy, we can expect to see coordinated data protection claims. At the possibility for regulators imposing a ban on the processing or suspension of data transfers, criminal sanctions or reputational damage, not complying with the GDPR simply isn't going to be an option. Clear risk should companies get it wrong. But that's not the focus that we want to spend today on. We want to look at the substantive requirements of how you can get it right. So if the risk is ramped up, this isn't all we want to talk about, but to show how important it is to be thinking about this now and not see the 25th of May 2018 as a hard deadline. See it as a living, breathing process which starts now. Before I hand back to Olivia to go through the nuts and bolts of the regulation, we thought it would be useful to have a quick reminder of the key terminology, and broadly similar to what we're used to under the Data Protection Act. So, the employer, you're likely to be the data controller. Data subjects are anyone about whom you collect data. So this would be your employees and job applicants. The processor is anyone to whom you outsource the data processing to, which could be your payroll provider, for example. ICO is, of course, the Information Commissioner's Office, which enforces the GDPR. Now, the GDPR imposes tighter obligations on the data processing undertaken by the data processor in particular, but also on the data controller. We're covering that in a bit more detail later. GDPR regulates the processing of personal data, which we should continue to view very widely, because processing means anything at all, including just storing data. And now what processing is and who's involved, it's now time to look at what types of data you will be processing in a bit more detail. So under the GDPR, we still have the same two categories of data, personal data and special categories of data, which is currently known as sensitive personal data under the Data Protection Act. Definitions are broadly the same or in line with those we have under the Data Protection Act, but have expanded in some areas. And we've highlighted the differences in bold on the slide that you can see in front of you. The definition of personal data has been expanded in an attempt to widen the personal data net. And the most significant implication is that personal data now also includes genetic, mental, economic, cultural or social identifier information. Even cookies, mobile device IDs, and IP addresses are formed of online identifiers, which will form part of the broadened scope of data which needs to be protected. And the personal data has been expanded, so it's no longer a requirement that all of the data which will be pieced together to make an identifiable person have to be held by the same data controller. You can work out who somebody is by piecing together all the different bits of the data that you have. That will make it personal data. And special categories of data now include genetic and biometric data, so new things that we're seeing like fingerprint and facial recognition technology data will also be caught. So what are some changes? Fundamentally, in HR, the change in definition is likely to have little practical difference, and if information that currently falls within the scope of the Data Protection Act, it will also fall within the scope of the GDPR. Let's take a quick look at some examples. Set out some examples of personal data on the slide that you can see. Quite a lot of this is obvious examples. We've got the employee's personnel files, medical information, but maybe some less obvious examples would be information about an employee's disciplinary investigation, their IP address, their bank details, even their business email address, which normally consists of first and last name, would fall within the category of personal data. So that's background for you, and I'm now going to pass back to Olivia for the nuts and bolts of the regulation.
The GDPR, personal data must be processed in accordance with 10 key principles. Now, they're on the slide in front of you, and as you can see, these are broadly similar to those under the Data Protection Act. Therefore, we can transfer a degree of knowledge and won't go into all of these in detail. However, for a number of these principles, the wording's changed, it's been updated, and most importantly, they all centre around the concept of accountability. What this means is that it's not enough to comply with GDPR, you have to demonstrate compliance. And we've also factored in the new overarching burden of proof that sits with the data controller rather than the individual. It's clear that these principles require a lot more proactivity on our part as data controllers. So the approach is called by design and default. And this means that there's a new aim to essentially put data protection up there as the #1 consideration in any early stages of any business or any HR project and throughout the data life cycle. Now, this is just partially new, but does have a much higher relevance in practice, whereby it now sits hand in hand with the principle of accountability. So protection by design means that data protection considerations should be embedded into design when implementing any new HR process, be this, for example, recruitment, performance management, promotion, disciplinary capability, etc. When designing any HR project, building new systems, developing new policies, or embarking on any new data sharing initiatives. It's all about front-loading our approach to data and making sure we've thought through the issues we're going to cover today before the data is collected. Now, they require a new approach, and those running HR functions need to think through the entire life cycle of HR processes, from point of collection right the way through to the point of destruction. Many HR processes are designed like that. Your organisation may have carried out privacy impact assessments for core HR processes, but for many this just doesn't or hasn't yet happened. Data protection is very simple. Essentially, if an individual does nothing, then their privacy should remain intact. It should be inbuilt into the system. So the way forward here is that we need to have a comprehensive understanding of the functionality of our HR systems, and we can then look for ways to use the technology to implement these principles. for example, by locking down data entry fields or restricting access lists. So the next part of the session is to highlight the changes that should be on HR's radar. Now, important just to note here that the principles and changes that we're going to talk about do relate to data processing throughout the business, be it client data or online data, but they are of particular relevance to the HR space. So there are key areas of focus for HR, which are on your slide. This is going to be quite a lot of work. So what we need to do is we need to be smart and we need to prioritise according to risk. The CEO do not expect us to have sorted this all out in one go and be up and running by May next year. They're looking to us to adopt a risk-based approach to implementation because bottom line, there isn't one quick GDPR fix. It's an issue as we run through these focus areas of deciding what's of particular relevance to you and your business. So the first we're looking at is that of consent. So this is a change which HR is likely to feel very directly. When we talk about consent, we're talking about using consent as grounds for processing employee personal data. It's not quite the silver bullet for GDPR compliance as the papers would have you believe, and we'll look at this in a little bit more detail. Now, you may all be familiar with the approach on the slide to seeking agreement to the processing of data. Bottom line, this approach is on its way out because GDPR addresses what's seen now as being an over-reliance in the employment context to these sort of standard consent clauses. So, lawfully, we have to tick one of the criteria on the slide. You'll notice that consent is still there. It remains under GDPR a legitimate basis for processing personal data. But whilst consent is one way to comply with justifying processing, it's not the only way. And GDPR essentially wants us to look around and take notice of these other lawful ways of processing data. And the ones on the slide are the key ones relevant in the employment context. With consent, what GDPR does is raise the bar to a much higher standard for consent to process personal data, thereby encouraging use of the other justifications. Consent should be freely given, specific, informed, and clearly indicated by a statement of affirmative action. It should be unambiguous and clearly distinguishable from other matters and be easy to understand. Now, this higher standard makes it very difficult for employers to rely on consent as a basis for processing HR data. This is because there's an inherent imbalance of power in the employment relationship. So consent is not freely given. Secondly, by including consent in standard clauses, such as the one we've previously seen in employments of contract, we are not assuring that it's clearly distinguishable from other matters. Consent also comes with supercharged rights in relation to data portability and the right to be forgotten, which I'm on to look at later, as compared with the basis for processing of legitimate interest coming with fewer rights. And this is another reason to cause us to think twice about relying upon consent going forward. Let's have a rethink here. There is without doubt still a place for consent, but we need to change the way we set out our consent mechanisms. They need to be clearer and have a much more granular opt-in of methods with clear records of consent, separate from the terms and conditions with clear methods of withdrawal. Importantly, we can't use blanket data protection consent clauses or pre-ticked box. So GDPR is all about introducing a much more dynamic approach to consent. The ICO refers to this as organic, ongoing, and an actively managed choice. So what would we be doing? Well, what we do is to stop and think about whether it's actually more transparent and more appropriate going forwards to rely on an alternative legal justification for processing data. And there are three which are most likely to apply in the employment context. First of all, it's necessary for the performance of the employment contract. Now, under old law, the term necessary was construed quite narrowly, and this is likely to continue. Therefore, this ground will be appropriate to cover processing with a very tight nexus to the employment contract, such as payment of salary, benefits, processing of requests for sick leave or holiday. For processing, we will rely on the second ground, that is in the legitimate interest of the HR function, provided, and this is crucial, that it doesn't override the rights and freedoms of the individual. And samples here are, for example, using contact details to arrange business travel, review performance appraisals for succession planning, transmitting personal data within the group for internal admin purposes, and pressing employee data to ensure information and network security. Bottom line is you know your organisation best, and you will be able to identify your purposes for processing HR data. It just requires this to be given some thought and us being clear about what this reason is. Ground, albeit slightly less common for processing data, is compliance with a legal obligation. However, in the HR space, this will justify a fairly wide range of HR data processing. For example, processing of trade union membership to deduct fees from payroll, reporting salary information to tax and social security authorities, and diversity reporting. The last two, which appear on the slide, are less likely to be used for day-to-day HR processing. So whilst identifying an alternative lawful ground for processing is unlikely to be difficult, it will require thought in the employment context. And minimization principles, which we'll come on to look at, may restrict the range of employee data which can be collected and what that data can be used for. We're expecting the publication of some consent guidelines from the ICO towards the back end of 2017. However, this is not a reason to wait to address this area, as it's unlikely to change much on the information we're giving you today. In terms of action points, you are not required to repaper existing consents if they are GDPR compliant. If it's not needed, an alternative to consent or to seek fresh GDPR compliant consent. However, you should begin now to look at what data you process, the grounds on which you process it, and then go on to determine what's the applicable ground for lawful processing, essentially starting the data mapping process if you haven't done so already. It will have a knock-on effect on the information which will be contained in contracts of employment. These will need to be reviewed and rewritten, and also in respect of your privacy notices. Moving to the next point, employees will be armed with a suite of so-called supercharged rights. Whether they are supercharged remains to be seen, and we'll come back to that later on, but these rights, without a doubt, are aimed at giving employees more control in certain circumstances over how their personal data is processed. The individual rights are set out in the slide, the key ones being the delete it, freeze it and correct it rights, in other words the rights of erasure, restriction of processing and rectification. Now some of these are old, you'll be familiar with these from the Data Protection Act, some are new and some are enhanced. First at the right of access. Going under GDPR, there is a specific list of information to be provided to employees and contained in privacy notices. Also, different requirements if the information is collected elsewhere, including, for example, the employee being told of the source. And individuals, as Rachel will come on to later to look at, will be entitled to access and have a copy provided of their data. Moving to portability and objection, it will have a new data portability right, which will allow them to request that certain personal data is transferred directly to a third party. It's essentially a pick it up and move it right. Now, it will only apply where relying upon consent to process or where it is required for performance of a contract and when processing is carried out by automated means, so in fairly limited circumstances. The right of objection also only applies in certain circumstances in the employment context, essentially where processing is based on legitimate interests. Where this right is exercised, processing must stop until you're able to balance up whose rights prevail. Does business have a compelling legitimate grounds that override the individual rights? One aspect of GDPR has been the right of erasure or the right to be forgotten. Akin to requesting your neighbour return the bowl of sugar you lent them. It's yours and you want it back. And this right to be forgotten is best known in connection with the ruling that EU residents can request outdated or irrelevant information to be removed from search engine results. Now, this isn't new. The principle was enshrined in the Data Protection Act, but the right was limited to processing that causes substantial damage or distress. While it isn't new, it is strengthened as the burden of proof means the business has to prove that the data should not be deleted rather than the individual proving that it should. It's an absolute right and can be triggered in specific circumstances as set out on the slide. If circumstances apply, the right of erasure must be exercised and the data must be deleted within 1 month of the request. In circumstances, however, where you can say no. The ones on the slide are the most likely to be used in the employment context. Action points. The biggest risk here to business is in respect of legacy data. The retention of historic information within HR about job applicants, performance or disciplinary records, or nice-to-have information which often sits in personnel files. The right to be forgotten rule may be problematic. Employees may query why you need to hold historic information about them and put pressure on you to delete it. It may be used, we're expecting them to be so, to hijack performance management or redundancy processes. Also pose a practical challenge for employers, particularly where employee personal data is backed up in inaccessible or complex systems. We need to consider how responding to these rights would be practically achieved. Boss be in a strong position to argue the right doesn't apply, and this is one of the main reasons why we want to move away from reliance upon consent. They would apply if we don't rely upon consent, if we can show the data is still necessary for the purposes for which it's collected, or if there's a legitimate interest to continue processing. So the key point is to make sure we have an up-to-date and relevant retention policy in place for different types of data. If we so, then this right is only likely to apply in limited circumstances. Of rectification. Rectification rights, of course, existed under the Data Protection Act, and they're fairly similar. But the rectification can be triggered if data is inaccurate or incomplete. How a key difference moving forward is the option on data controllers to notify third parties in the event that data is amended. We need to consider what procedures should be implemented to action this obligation. The relevant deadline here is 1 month or 3 months in more complex cases. This right, such as the other, akin to the other rights we've just looked at, has the potential to cause workplace disruption. The right processing, this is new and can be triggered again in specific circumstances as set out on the slide. Key is it is sufficient in response to archive or move the data to another system. Your final bullet point on the slide, again, there is an obligation to notify, to inform relevant third parties when this right has been triggered. In terms of points, we've set out the key ones on the slide. Essentially, we need to be addressing, can your systems cope with these rights? Policies provide for them? Are your HR staff aware of them? And remember notification of third parties. So a quick reminder of the HR focus areas and where we have reached. Forwards, the principles of limitation and minimization, these go hand in hand, and essentially what these mean is that information must be targeted. It only process data necessary for the purpose it's being collected for, and then if it's limited and minimized in terms of the amount you collect, what you collect, the extent of the processing, and period of storage. Once data is no longer needed for the purpose it's being collected for, it should be deleted unless the ongoing purpose for which the data is collected is compatible with the original purpose. For example, data collected for first stage performance management process at the end of stage 1 can be retained as data as part of the ongoing performance process, and this is clearly compatible with the original reason why the data was collected. Address some action points. Principles are of significant importance to HR and will require review of the way in which data is used and collected throughout the employment life cycle. Some practical examples. We'll need to take a critical look at the current application procedure and ask questions such as, is all the information needed to make a proper assessment? Whether the data of candidates who aren't employed should be deleted shortly after the recruitment process or within a more limited timescale, unless candidates have, of course, given explicit consent. This is data of current employees. Previously, businesses were able to collect generic data such as civil status, number of children, driving licence details, etc. But going forward, it's going to be much more difficult to justify collecting data which is not directly related to the role or the management of the employee. So we consider how long we retain our data for. For example, data that we've collected in relation to performance assessments. Retain it no longer than is absolutely necessary. At the back of the employment relationship, the data of employees who leave a company should only be retained for a limited amount of time. Without a doubt will affect the offboarding procedures of many businesses. Going forward, delete employee data should be added to the drop-down to-do list, and as well as hand in work phone and hand in work key. This may therefore impact or hinder your ability to maintain a talent pool, as storing personal contact information for use in the future without permission is not permitted. We need to have a regular review process in place and a methodical cleansing of HR databases. This can be tricky when we're collecting data in a haphazard way with sophisticated end-user devices such as smartphones and laptops. We need to work with IT to ensure how this can be done. To approach this is to develop a retention schedule and to break down what needs to take place into bite-sized manageable chunks. We'll list all the different types of data processing, and then consider the practical questions such as, how long do I need to keep CVs of rejected applicants or of successful applicants remain? How long do I need to keep leavers details? We then go forwards and develop a policy around these rights, and finally design systems to deliver against the policy. Leave certain principles to last. These are without a doubt the principles of transparency and accountability, which are summarised on the slide before you. Now, these are absolutely fundamental to GDPR compliance. Obviously, for many HR teams, data protection with compliance was about having a data protection policy, standard consent clauses in contract, and filing data as it comes in. We're now moving forward to much more active governance. We'd like to focus on one area where GDPR will necessitate a change of approach for HR, and this is in respect of privacy notices. Now, obviously, privacy notices, if you have them at all, are most likely to be found sat on a portal and will say something along the lines of, we are managing your data in accordance with your rights as data subjects. However, we need a completely different approach going forwards, whereby all the information is given to the individual, and that includes employees and job applicants, at the time the data is collected and is kept up to date. This needs to be a concise, accessible and a live document. Bear in mind this is all about transparency. Keep employees or prospective employees informed and updated, and essentially giving them an insight into the specifics relating to collection, storage, use and transfer of data. In terms of content, our privacy notices will have to be more comprehensive. Regulations set out a more detailed set of information to be provided, as set on the slide, particularly in relation to the purpose of processing and means by which personal data is processed. What needs to be included includes, for example, the right to withdraw consent, the right to object, rectify or complain, the duration of storage, whether there is intended to be or may be an overseas transfer, who will be the recipients of the data, the identity of the controller, the purpose of processing, and which legitimate interests are relied upon. Also has access to the data. We are going forwards going to have to review our privacy notice and double check against this list. And without question, all are going to require updating, if not a rewrite. Being match ready for the 25th of May 2018. So what do we need to do? We've been mandatory requirements. Essentially, we need to revisit and consider all 8 areas we've looked at in this session. The majority is part of the wider business GDPR exercise, but you still within HR need to consider each and have input in the context of employee and job applicant data. Employees need to consider whether existing employee and applicant privacy notices meet GDPR requirements, and consider how clarity and accessibility of notices can be ensured. And these are issued to staff in advance of GDPR taking effect. The new need to be kept under review to ensure they capture any new types of data or any changed uses for that data. Hand back to Rachel to move forward and look at subject data access requests, criminal record checks, and a couple of other points which you'll need to consider going forward.
Thank you, Olivia. So here's a quick reminder of what we've covered, and let's move straight on to data subject access rights. So data subjects, be your employees or ex-employees, have the right to ask to see the information which you hold about them, the dreaded data subject access request. So this is something we're familiar with under the Data Protection Act and remains in the GDPR. How the current period for compliance with a data subject access request is 40 days. Under the GDPR, this is changing and is being replaced with an obligation to comply with a request without undue delay and within 1 month. This is something as well that can be extended to 3 months where it's necessary for a complex request. And we all know that data subject access requests in an employment context can be particularly challenging, and this is because the information is often unstructured and is spread out across different systems. So it may be that the normal period for compliance will by default be stretched to 3 months in an employment context because of the complex nature of gathering all the information. And this may be something we can use as a tool to our advantage to get employees to narrow the parameters for their request. If we can explain to them that narrowing their search parameters might enable us to respond to their requests quicker, you might think about that again. In addition to the actual data that you have to provide the requesting it with, you now also have to tell those who request their data a few extra points, such as the envisaged period of storage for their data and information about their rights as a data subject regarding their data. For example, all the points that Olivia's just been going through about them to be forgotten. A change is that the £10 fee for data subject access requests is being abolished. However, where a request is manifestly unfounded or excessive, you're entitled to charge a reasonable fee to take account of administrative costs. Request falls into this scenario, though, will depend upon the circumstances and might be a difficult judgment call. If requests are manifestly unfounded or excessive, you can also have the option to refuse to respond. But if you do refuse to respond, you have to explain to the individual and inform them of their right to complain to the supervisory authority within 1 month. So this might be something that isn't actually used very much in practice. And hopefully these changes should discourage very onerous requests. But what can we be thinking about now in terms of action points? So it's advisable to make sure that you can quickly and reliably aggregate all the personal data scattered across the company's different systems, network folders, emails, employee devices to make sure that you can comply with a shortened deadline of 1 month. You would need to update your relevant policies and procedures to ensure that you're reflecting this new PR regime. You might also want to start thinking about whether your IT systems are smart enough to retrieve all this data, or even whether employees should be able to access more of their personal data online in an attempt to mitigate the need for them to ask for a data subject access request in the first place. Move on now to automated decision making. So essentially this is where decisions are made without any human involvement, which is actually becoming more common in an employment context. For example, in relation to processing sickness absence data, attendance data, warnings, and also where companies rely on e-recruiting practices. So under the GDPR apply to any auto decision. The processing can be carried out where it is necessary for performing the contract or where authorised by law, and there are sufficient safeguards in place. GDPR sets out an individual's right to object to auto decision making if they are significantly impacted by the decision. If they do object to you auto decision making, this doesn't stop you from processing the data. It just means that you have to do it in a different way, i.e. with some human involvement. I have to note here that member states can derogate from this and restrict this right for individuals to object to auto decision making. And the UK government has made it clear in their statement of intent that will restrict these rights for an individual to object where legitimate functions rely on auto decision making, for example in e-recruiting practices, provided that appropriate protections are put in place, which include a right of recourse to seek human intervention. And this is something we're monitoring, so we're going to have to watch this space until we know a bit more information. We need to quickly touch on criminal records checks under the GDPR. Now, the GDPR only permits bodies who are vested with official authority to process personal data on criminal convictions and offences. But again, something that in the UK government's recent statement of intent, it again set out its intention to derogate from the GDPR on this point, and to continue to allow a wider range of organisations to process criminal convictions and offences. And the government has said that they will extend the right to allow businesses to process criminal records data, and this data will be treated in the same way as special categories of personal data. So what it means that businesses are no longer able to process this information as a nice to have, it means that you can continue doing it if it's needed to manage risks for a lawful reason. For example, to protect vulnerable individuals or children. Now covered that swiftly, I'm going to pass back on to Olivia.
Thank you very much, Rachel. We are fastly approaching the end of this webinar, so thank you for bearing with us. I'm now going to look at what happens if it all goes pear-shaped and there is a personal data breach. Under the new rules, employers will be required to report a personal data breach to the Information Commissioner promptly and within 72 hours if feasible. And if time frame is missed, then you must provide to the ICO a reasoned justification for the delay. It's important to note here that the term personal data breach covers all kinds of commonly occurring workplace mistakes, such as a laptop or a file being left on a train or an email being sent to an incorrect address. However, there is no requirement to notify if the breach is unlikely to result in risk to data subjects. For example, where a lost laptop holds only encrypted data. There should internally be an initial point of contact to whom any potential breach should be reported to, and that person should have had training in order for them to be able to assess whether there is likely to be a risk to data subjects, and therefore whether the requirement to report a breach to the Commissioner is triggered or not. Plan here. Establishing a data breach response plan is key. Employees must be made aware of how to report breaches, to whom and when. And crucially, so as not to deter employees from reporting breaches, it's important that businesses don't fall into the trap of creating a blame culture. We need a clear policy on how to handle a breach with a designated point of contact with authority to report to the Commissioner, and to consider how records can be kept of reported breach and action which is taken. We'll look at training going forwards, as there'll be a need to educate employees that even apparently minor incidents must be reported internally if data has been lost or compromised. Now, HR, this presents a twofold challenge. Should a breach originate within HR itself, then effective coordination between HR and an organisation's legal and or compliance teams is likely to prove critical, especially when you consider the tight time frame for response. In addition, should the breach affect employee data and require data subject notification, HR is likely to play a key management role. So in compliance will likely require a complete review of your internal policies and procedures with a particular focus on efficient internal communications. On to look at data security. One of the main goals of GDPR is to ensure the protection of personal data. And this means quite simply that data must be stored safely and securely. Internally, data security must be well organised too, and only a limited amount of individuals should have access to confidential information, especially within the HR space. So collaboration with IT is going to be necessary to find the right balance between data retrieval and how to protect that data from external threats. And the GDPR, like the Data Protection Directive and Act, personal data must be protected against unauthorised access using appropriate organisational and technical measures. Data controllers and processors will need to assess risk and implement appropriate security for the data concerned, and crucially check on a regular basis that it is up to date and working effectively. So, is pseudonymisation a way out of all of this for HR teams? The GDPR introduces this new concept of pseudonymisation, which means the processing of personal data in such a manner that personal data can no longer be attributed to a specific individual without additional information. And such data will still be treated as personal data, but will crucially be subject to fewer restrictions on processing if the risk of harm is low. It does, however, require that keys necessary to identify data subjects from the coded data are kept separately, and again, is subject to technical and organisational security measures to prevent inadvertent re-identification of individuals or personal data within the data set. The practice around pseudonymisation is currently fairly varied across EU states, which we're conscious is unhelpful for multinational employers. We are expecting EU-wide guidelines which should eventually help employers navigate this area. To bring us to an end, what should we do now? First of all, before we look at the bigger picture, let's start with some good news. It's not all about creating a lot more work for HR teams. Good news from the ICO is that SMEs are not going to be top of their hit list in terms of looking at what Ray described earlier as the eye-watering fines. The ICO are going to be looking first at large companies who process vast amounts of data, who will essentially be the ones causing harm if they get things wrong. Bottom line, the ICO need any action taken to be dissuasive, and this is more likely if it hits the larger, well-known brands rather than SMEs. The bad news is that there's no overall carve-out for SMEs for GDPR. The logic is they may be small but may still be processing a lot of data. For example, technology clients who are big data businesses processing terabytes of data. It's important to remember that these tougher data protection rules are a two-way street. So to protect your organisation against the greater sanctions of the new regime, you'll certainly be entitled to toughen up how you deal with data breaches perpetrated by your staff. So the increased scope for your organisation to legitimately use employees' data protection obligations as leverage in employment disputes. For example, a departing employee who takes lists of clients and customers and contact details will now run the risk of being reported to the Information Commissioner. You'll also be justified in taking a harder line in disciplinary action against employees who misuse confidential information about third parties or remove it from your secure systems. Now, it's all about being match ready for the 25th of May and then treating GDPR as an ongoing compliance exercise. It's certainly not a case of being ready for the 25th of May, then moving on to the next big thing. GDPR compliance should be a recurring item on the boardroom and business unit, including HR agendas, as it's not a one-hit wonder. Now, business already has a policy and procedures in place to meet the requirements of the Data Protection Act, then you'd have solid foundations to comply with GDPR. The GDPR very much builds upon what's already been established by the Data Protection Act. It will, without a doubt, require engagement across the business to embed this into the organisation, and will need a steering committee. It's not an HR-only issue. First thing to check is who's taking ownership of this as an issue, and who are key stakeholders, HR and elsewhere in the business, compliance, legal, IT, finance, marketing, etc. We need to have a business-wide approach to defining strategy, undertaking audits and privacy impact assessments, and establishing policies and procedures. Can't and shouldn't do it alone, as the HR piece is just part of a bigger picture. So to the specifics of what to do, this first stage involved doing an initial inventory, the data mapping exercise, looking at your data, where it is, what it is, and what it's for. Then look at your systems, what do you already have in place at the moment. You review your current practices against GDPR requirements and then assess risk. We need, as we mentioned earlier, a risk-based strategy, as otherwise, quite simply, there's far too much to do. An approach and action plan that focuses our time and resources on highest areas of risk first, and is defendable, therefore, to regulators and management if there is an incident. Then the exercise requires project management, scoping the project, set timescales and implementation, and importantly finding the right people with time outside their day job to be able to undertake this. And necessary, it may require buying in of new technologies and getting the right resources. You'll have to consider what steps are necessary to assess the risk and to address that risk. And as mentioned earlier, this will require going back to the board in relation to some documentation, most notably in relation to HR in respect of contracts, handbooks, policies and privacy notices. Now, training is going to be of fundamental importance, both general training for the wider business and also specific training for those who handle or process a lot of data. Now, people going forwards are going to be your biggest strength and biggest weakness. They can make mistakes, they store information in the wrong place, and make shortcuts which puts data out of control of the IT department. So you need to understand how your employees share information and then consider appropriate employee education or awareness programs or cultural changes to plug the gaps. Going forwards, you'll need to put in place a system for ongoing monitoring to ensure that controls are implemented and adhered to. For example, dashboard reports on completed training, audits of internal end-to-end HR processes. Essentially, we need to be moving away from tick box compliance to a living, breathing programme of GDPR compliance and active management. So by just reminding you again of the final principle under GDPR that states that data controllers must be able to demonstrate compliance with the other principles. This is a fairly short sentence with major implications. It's not enough to comply, we have to be seen to be complying. But also just to remind you that there's no need to panic. This massive fines is scaremongering, and they're very much the sledgehammer in the ICO's toolbox and will be a place of last resort. They very much want to use the carrot and not stick approach and encourage businesses to work now towards compliance. In the shadow of a doubt, there is, however, a lot to do, and the time to get started is now. And if you need more help, we have produced a GDPR for HR product which provides 3 levels of assistance as outlined on the slide. And if this is of interest, are more than happy to either come and meet you or have a telephone conversation to discuss your business needs and how we potentially can help. Any specific questions arising out of this webinar, then please feel free to contact Rachel or myself, who will be delighted to have a chat with you. Thank you much for your time, and we hope you found this webinar both of interest and of value to your GDPR exercise going forward. Thank you.